Hi, and welcome to Everyday IP on our Decoding IP blog. I'm Jennifer Atkins, and with me is Amanda Hebert. It's been a while since we've been on the air. Lots of changes have been going on. You'll notice that our logo on the front was no longer Cloudigy Law. We are Protore Law now. We've got lots more information about that change coming up, but we wanted to get right back into where we left off with our Everyday IP live streams, because whether we're Cloudigy or Protore, we are still interested in helping you find, grow, and protect your content and creations. And that's why we do these shows and try to make them informative and talk about things that are going on in the world today that might impact you. So we started off, actually, I wasn't here, but I got to watch Antigone and Amanda talk about real trademarks in virtual worlds. And so we're going to continue on that theme today. Last time, Amanda, you guys really focused on people who are playing games and living in virtual worlds, creating things, right?
Living is a strong term, but yes.
And so you guys talked a lot about trademark in the context of, if you're creating something in a virtual world, does it really constitute use in commerce? Is it trademarkable?
Exactly.
And that kind of stuff. Today, I thought one of the things that sort of y'all didn't talk about that I'm interested in is, what about the opposite, right? Which is real world products or services that are trademarked translating into the virtual world of games, whether they're video games in the traditional sense that we think about them, or these online interactive games. And unlike the scenario you guys talked about last time, which there's basically no case law on.
Loosey-goosey, wobbly-gobbly.
Yes, exactly. Timey-wimey things, right? In this context, there is a ton of case law. Well, not a ton, but there is case law.
There is some case law, and it seems to be gathering strength as it goes as well.
Right. And so one of the things that I find fascinating about the IP area is that it really often is at the forefront of technology developments, right? And changing in how we think about these areas of law. So why don't we kind of delve in, I think, to the case law, and people will recognize sort of one of the more famous video games is Grand Theft Auto, and not surprisingly, Grand Theft Auto has been at the center of some interesting cases, right?
Well, if you're a satirical video game, there's not really much else you can expect.
Right. So tell me a little bit about how Grand Theft Auto is sort of at the forefront of trademark, well, IP, not just trademark, right? So yeah. We have trademark and right of publicity and trade dress, right?
Yes.
Yeah.
Well, as you guys can see from the images, it's impossible to talk about any of these issues without somehow bringing up a Lindsay Lohan lawsuit.
All right, right of publicity, you're going to be talking about Lohan.
Indeed. Grand Theft Auto has not been missed in this. Miss Lohan sued Grand Theft Auto for a right of publicity case in their character of Lacey Jonas, who you can see as the cartoon figure in that image. Mm-hmm. Basically, she said, hey, your character Lacey Jonas is doing my trademarked peace sign in a red bikini picture, and she has an eating disorder and is a socialite and runs from the paparazzi. You totally just stole my story, and sued them for misappropriation and right of publicity. And the court said, no, this is fair use. This is satire.
Yeah. And so the concept there, Lindsay Lohan was saying, hey, you're stealing me. You're sort of, when we talk about right of publicity, and Candace and I did a podcast on this a while back, where the Littlest Pet Shop had created this toy that was based on a real life newscaster, and the newscaster sued and said, hey, wait a minute, you're taking away a right that I have to publicize myself. So it's not necessarily a trademark, but it's a kind of similar thing in the personal publicity world. And the case ultimately settled, I think, which is probably a good thing, because it looked like it was going to go the way of the newscaster, right? Here's a different story, right? Where Lindsay Lohan is saying, hey, you're using me. This is clearly me. And the court says, satire, right?
Yeah, the court says, yeah, maybe it evokes her story a little bit, but they weren't even biting that far. They said the fact that the characters who are playing the game can choose whether to follow her storyline or do the paparazzi quests or not played a part in the decision. Yeah. But also just the fact that in order to be a successful satire, you have to evoke a real world person, image, or idea.
Right.
Satire off of, they said that's completely fair use and you have no lawsuit.
And what's interesting here is that sort of right of publicity often implies endorsement, right? And
Exactly.
so, and they basically, the court was like, look, no one is going to think that you, Lindsay Lohan, endorsed this game or made this game or somehow associated with this game. This is clearly satire, right?
Yes.
Which is interesting because the court then is looking at these games like literary works.
Actually,
right?
that's been a strong trend.
Yeah.
It's like games are becoming more and more a new vehicle for telling stories.
Right, which is it's sort of more like a book, more like a movie, more like a TV show in terms of how we view what this is, right?
And if you look at some of the franchise agreements that are going out, like I think Rothfuss just did one that includes movies, TV shows, and video games,
right?
Because, which is for his whole series, which is kind of crazy, but I can't wait to see how it turns out.
Right, we're viewing them as storytelling vehicles, and that actually really played into this concept of literary satire, right? That's sort of the same idea, like, you know, that you're allowed to do this. But that's not the only thing. Lindsay Lohan is not the only thing that Grand Theft Auto was taken into court on. The other one, and I cannot believe that we're talking about this yet again.
Better believe it.
On this, is a strip club, which is, I think this is at least the second, possibly the third time in our podcast and live stream world that we're discussing strip clubs. But the Playpen strip club, right? So
yes. So, well, Grand Theft Auto as a satirical video game is kind of taking a gritty dystopian Los Angeles or Las Vegas or whatever city they choose and portraying it in a storytelling sense where the characters can kind of go and live in that sandbox of a world. And part of that is basically reproducing parts of those cities. And so you have this real world strip club, the Playpen. It's in a strip mall, it's near a highway. It kind of looks like the in-game representative, the Pigpen. And actually you can see the Pigpen on the screen there. Basically, it's just a strip club where people can go and do quest lines or, you know, solicit strippers.
Do the things one might do. Eat a steak, right?
But in this case, actually, the Playpen, the real world strip club, sued the video game designers for trademark infringement of their store dress and whatnot. And the court said, no, there was no likelihood of confusion here. No one's going to mistake a strip club operator for a video game designer or a video game designer for a strip club operator, although depending on who listening.
I was going to say, I don't know. I mean, you could.
And they also said, what's more, it failed the Rogers test.
So you just mentioned the Rogers test, so I think it makes sense to talk about that now. So we're two cases in here. What's the Rogers test?
The Rogers test is something that courts have been increasingly using to analyze fair use, free speech, legal issues in the context of video games. And it's a very pro-defendant standard. It basically just asks if the defendants have any sort of artistic relevance for their use.
Any,
and I do mean
plus one,
any,
right?
any artistic relevance for the use of it.
Mm-hmm.
And on the other hand, it asks the plaintiffs, hey, can you show that the defendants were explicitly misleading anyone with their use?
Right.
And that's a much higher standard to me. It requires affirmative action or some sort of misrepresentation that can amount to that.
And what I think is really interesting here, in particular in the game context, and I think this comes up in Grand Theft Auto for sure, and definitely in other games, is it's evocative, right? We're trying to set the scene, we're trying to set the mood, we're trying to make this evocative of a real place, right? And so I think the court was sort of going with that, right? No one is trying to say this is a sponsor of this game. Everyone sort of knows that this is just trying to set the scene.
And what's more, using realistic strip clubs is relevant to the video game's designer in this case of portraying a realistic but gritty world.
Yeah.
It was viewpoint-based expression and it's protected.
So we talked about the Rogers test and how it's sort of developing in a very defendant-friendly way, but defendants don't always win. Like, I don't want everybody out there to be like, oh, good, there's no such thing as infringement in the video game world, because that's not true. Let's talk a little bit about a case that came out the other way, right, where the defendant lost.
So Trexton Helicopters is probably what you're thinking about.
Yeah.
That's a video game where they reproduced, it was Battlefield 3, and they reproduced these helicopters, real world helicopters. I believe the models were AH-1ZUH. I can't remember. But they took these real helicopter models and reproduced them in the video game. And the helicopter company Trexton sued for trade dress infringement.
So not trademark.
Trade dress.
They weren't saying Trexton anywhere, but for trade dress, which is the look and the feel.
The overall look of it, the packaging, so to say.
Yeah.
And actually, the helicopter company won.
Yeah.
The court said, if you assume everything that they alleged was true, that it is reasonable that people could have thought that the video game developers couldn't have created those helicopters because they were so highly technical and accurate to the real ones without the help of the actual helicopter.
Which is really interesting because we get back to this implication of endorsement, right? Which is we talk about in the right of publicity context, but it's also when we talk about trademark and trade dress, part of the issue is, will people be confused about the source of this product? Will people think that there's some kind of endorsement or connection implied, right, by the use? And it was sort of interesting that the court was like, well, you know, a building, a strip club with a sign that's a play on it, you know, anybody could kind of do that, but this really highly technical piece of equipment,
reproduction
right?
Of the buttons,
right?
The UI of a helicopter, like, they thought that it's reasonable and therefore explicitly misleading.
Right, that it implied that somehow Trexton was involved with the game. So you're not really out of the woods in terms of that, but you know, following along sort of in the war game context, because I thought that was really interesting, that like where we sort of start to see some plaintiff friendly action and decisions is kind of in this military industrial complex area, but it's not always the case, right? So there have been shockingly enough, in these games that involve shooting, there are guns, right?
Gee, I never would have thought.
Right, and so there are video games that have used trademarked guns and other things,
right?
And so,
and actually, EA has kind of been at the forefront of this issue because they've actually made some public statements saying, "Hey, we're going to keep using branded guns in our games, and we're not going to get licensing rights from them because we think we're allowed to."
Yeah.
And they've actually come out and said that. So they've kind of been at the lead, and kind of in line with that is the Godfather 1 and 2 games by EA. They used, what are they called?
Tommy guns.
Thank you,
yes.
Tommy guns. They use Tommy guns in those games. It's the Godfather franchise. It would be weird if you didn't use Tommy guns, but they call them Dillingers, and Dillingers are a particular brand of Tommy guns made in Indiana. And of course, the company sued, said, "Hey, you can't use our Dillinger guns in your game without our permission." And the court said, actually, they can. The Godfathers are telling a story. It's protected artistic expression. It's relevant to their story that they have realistic guns in it. And we don't think it was explicitly misleading because everyone knows that the gun manufacturer is not the video game.
Not making the video game.
And actually, I think it's really interesting here is that the court specifically said that the Dillinger Company guns are so well known in the world, the real world, that no one would mistake it. And that's kind of the opposite of trademark,
right?
Where well-known marks are usually better protected marks.
It does seem to be a little bit backwards reasoning from a place where you're trying to, where usually you get to say, hey, I am super famous, so I get kind of extra protection almost, right? And here it was almost the opposite. Like, you're so well known, you couldn't possibly write a mafia-related story without using your guns, right?
Exactly.
Which is kind of interesting. So those are cases that have happened, but this is not the end of the story by any means. The Rogers test is out there being used. Courts are struggling with these issues. And while EA has come out and said, hey, we think the law allows this, we're going to go forward, there are still cases that, you know, going forward has risks, right?
It does.
Yeah.
Because until the law is so prevalently one way, people are still going to argue it. And face it, writing a cease and desist letter is relatively inexpensive.
Right.
Also.
Suing might be expensive, writing letters not so
exactly.
much, right? So there is a current case actually going on the Gears of War, keeping in our war theme. There's a current
games like guns,
right? Games and guns. So let's talk a little bit about that, because again, this is, I think, on the right of publicity side, right?
It is. It's a right of publicity case. In this case, Coltrane said, hey, you Gears of War have stolen my persona by taking my general appearance, but also my voice. And he said that the voice actor and Microsoft literally tried to reproduce his voice exactly in creating that character, and he had voice analysis done on it, and this is all part of his lawsuit.
Interesting.
So I don't think I've ever seen anyone trying to say voice misappropriation.
Yeah, it is really interesting.
Before. I've heard of it in music context before, but so that actually just happened. It was filed in January this year, and not much has progressed on it yet, but we'll definitely be monitoring it on our blogs and podcasts.
And this is a case actually in Pennsylvania. So normally that's kind of what's a little bit more interesting about this is we usually see this stuff in California,
New York.
And New York. But not so much in other jurisdictions. So will be interesting to see sort of how the Pennsylvania courts, which are not really used to dealing necessarily with these right of publicity, trademark type issues, IP issues. So let's get back, because earlier we were talking about the court's willingness to think of video games as literary works, as sort of storytelling, similar in many ways to movies and TV shows. But anybody who's been watching movies or TV shows for the last, 40 something years, maybe even longer,
probably,
knows that product placement is huge.
Just look at Project Runway.
Right? I mean, so we are used to in television and movies, I always laugh when you see like a cereal box that sort of says cereal on it, right?
Or when they open a fridge and all the sodas are blurred out.
Right. It's like not intentionally not using the brand names. And I think people think of that as, well, they didn't want to go get license agreements to show the real products. But it's also because
they don't want to risk getting sued.
Well, they don't want to risk getting sued, but also because TV and movies, it's not just about sort of paying someone to get licensing rights. It's actually selling the rights to be in my show, right? So if I'm the creator of Friends and I want to have my friends sitting around, drinking sodas, I might call up Coca-Cola and be like, hey, do you want Chandler Bing to be drinking a Coke, or do you want us to go call Pepsi, right? And so what I think is really interesting is it's almost the opposite world in the video game context, right? In a really weird way.
And I actually think it's, not to be too trite, but it's almost like it's a brave new world, because it's such a new genre that we don't have that long built up expectation of blurring products yet. And because trademarks are driven by what the consumer expects, our expectations having been built over years and years and years of experience of seeing, hey, this TV show blurs products, that means anything not blurred is probably sponsored.
Right.
And that's our expectation. So going forward, because trademark learns from expectation, you have to blur the products, or else you might be infringing unless someone wants to litigate it, which is expensive and risky and all of that. So video games are a new format. We haven't really seen much in this area yet. And actually over the years, there's been a trend against blurring things as graphics become better and people want to make it more crisp and more clear.
And more real.
Exactly. Right? And so what we're seeing is that there's no consumer expectation of blurring yet in video games.
And I think that, so this brings us back to how law changes and in particular trademarks, where the focus really is on consumer confusion, right? It's not sort of a, in copyright where we look at, well, how much did you take and does it really look like the photo, or did you take a whole paragraph or whatever, where it's sort of a much more like quantitative analysis, right? In the trademark world, it isn't necessarily, well, did you use the brand name, or did you use the trade dress, the colors and the whatever to be evocative? It's more, A, did you use it, and B, would anybody have been confused by it, right? What is a consumer expecting? Is a consumer playing this game going to look at that and think, oh, wow, Coca-Cola must have endorsed this game? And the court's reaction thus far has been no, right? Yeah. Everybody's going to know this is a game. Whereas I think in the television context, because we have this history, right? I do. And I was sort of thinking about this as we were talking, like, well, yeah, when I see a television show or a movie and it has, the famous example, right, is E.T. from when I was a kid, like E.T. with the
before
Reese's
my
Pieces.
time.
Like, before your time, I'm old. But E.T. was this, hugely publicized example of product placement, right? Like Reese's Pieces, and it was a huge marketing boom for Reese's, and it was a big deal. And so ever after that, if I see a product in a movie, I might think, oh, that company is a sponsor of this movie, that company agrees with this movie, that, somehow that company is endorsing or associated with this movie. And so I think that makes the trademark analysis harder, right?
It does, because consumers to a certain extent do expect it. And honestly, I think it's just gotten greater since ET.
Right. I think that it's really true. Now, whether or not in a real trademark analysis, you'd sort of come down on, like someone is confused and might think that the candy company made the movie, right? Like,
but often that's not the analysis that's
right.
going into this.
Right.
What companies are getting are cease and desist letters that are saying, hey, you're using our trademark, our trade dress in your movie. And if you don't want us to sue you, you need to blur it out or pay us for it.
Right.
And oftentimes a business making a decision says, you know what, it's
A
cheaper
lot
and less risky to either blur it or pay them for it.
Yeah.
And so because of this, we've gotten this expectation. It's almost kind of created a quasi trademark right that may not have existed in the first place had this entire practice not built up around it.
Yeah, I think that's right. So as always in these conversations, we want to try to bring it back to things that are relevant for you and your business and what you're doing. And if you are out there creating games or thinking of creating games, you know,
or seeing your trademark in a game,
what can you do, right? And so I think if you're out there creating games, you have to know that there's risk. You know, you could be EA and say, you know what, forget it. I'm telling a story. I'm evocative, so I'm going to use what I want to use to set the scene. And I'm going to think about how that's artistically relevant. What I think is interesting in the cases that have played out is there's sort of two themes, right? One is satire and evocation of character and place. And the other is, you know, things like the Tommy gun or certain kinds of guns that are, again, evocative of scene and place. As opposed to, I sort of am curious now about this candy example, right? Like, is it really artistically relevant if it's Reese's Pieces or if it's M&Ms or if it's any other kind of candy, right? I mean, I think sort of making that argument, right? But so I think about what that
because the standard is so low,
it would probably be.
Still be, it just has to be artistically relevant to the world you're creating, right? I don't know, maybe in your world people don't like peanut butter as much.
I know. But so I do think, you know, if you're out there creating these games, you want to give some thought to it. Understand that it's a risk when EA comes out and says, we're going to use these name brand guns and we think the law allows us to do it. You know, they're doing so knowing that they might draw a lawsuit, right? And so if you want to take the same stance as EA, be prepared that you're probably going to you might get a letter, you might get a lawsuit, and understand what you want to do, you know, from there. How can you be evocative without using necessarily the actual product or name brand? And the other thing is, if you see your trademark used,
realize they might stand up for themselves and defend against it.
Yeah, I think that's right. You still want to send a letter though, because
letters are cheap.
Letters are cheap. And also remember, if you're a trademark owner, one of your obligations as a trademark owner is to enforce your trademark rights, because if you don't continually enforce them, you could lose them. So even if you think, well, if somebody's using this in a video game, you know, maybe the law is allowing them, you still got to send that letter. You still got to say, hey, we think this is problematic. Even if the result is for $1, right? We'll let you do it, right? I mean, you're at least sort of still out there protecting your right. And so if it comes up in a real world, not a virtual world context, you can.
No one can use that instance against you.
No one can say, well, it's used in this video game, so, you know, they've sort of walked on their rights. So I think that's any other sort of practical takeaways from this?
As always, you should talk to an attorney if any of these issues actually come up.
If you've got a letter, you want to send a letter, you should probably talk to an attorney for sure. We appreciate you joining us. I think we're going to continue to see growth and development in the virtual world. This really is the cutting edge of intellectual property law, both from the game content side and from the player interaction side, and the sort of economy of second life and those kinds of games, and also from the, you know, inclusion of real world, like the transfer, right? It's like real world marks in the virtual world and becoming one world. We're going to continue to monitor it. Of course, if you have questions about this or any other IP topic, we welcome you to contact us. We are at ProTore Law now. You can find us on decodingip.com, which is our blog. You can find us on Facebook at Decoding IP. You can find us on Twitter at Decoding IP. And you can find us at ProTore Law. She's a Hebert at ProTore Law. I'm Jay Atkins at ProTore Law. And the rest of our team is here too. We'll join you in another couple of weeks with a new episode and take on things here. And as we get settled in our new digs, we'll probably have a more exciting background than this. Anyway, thanks for joining us, and we'll talk to you next time.